I want to talk to everyone about estate planning. It's a lot of material to cover, and it's going to be a very brief overview. We'll focus on what people want to hear about. So if you have any questions during the presentation, please raise your hand and I'd be happy to talk about anything specifically. Later on in the presentation, say the second half or so, we're going to start talking about Medicaid planning, which is nursing home care planning, which is a lot of what we just talked about with specifically with the funeral trust. This will be a more broad overview with more different types of methods and strategies for planning for nursing care. So my name is Dan Krause. I'm one half of the partners of Krause, Donovan Estate Law Partners. I founded this law office in 2000, and I brought in my partner in 2014. He is the taller and better looking one of us. He also has hair. And we met in the Army. We also met when he was an investigator for the Wisconsin Supreme Court. He was investigating attorneys who committed misconduct. Now, I'll give you just a second. He was not investigating me at the time, so just in case you were worried. So I took him out of the state service, and he brought his estate planning and his tax planning and his specifically his financial planning expertise into our firm. So we have 2 attorneys, 5 staff, and we're right across the street. So there's 2 main areas of estate planning. So I put a little cheat sheet for you. If you want to follow along, please go ahead and write down. It says Basics of Estate Planning Notes. And then there's 2 main areas of estate planning. And there's a 1 and a blank and a 2 and a blank. So if you go ahead and write down on there, the first area of estate planning is planning what happens after your life. What's going to happen to your stuff, mostly. And then the second area is planning during life. Now that's a strange order to put those in, but it makes the most sense when I talk about it in this way. So, estate planning is basically planning what happens after your life and planning what happens during your life if you are incapacitated or you have nursing needs. Now some people are in both categories. They're incapacitated and they have nursing needs. But some people have nursing needs when they're not mentally incapacitated. So this is what we're going to cover. Number 1, planning for after your life, then planning for during your life. Then we're talking a little bit about estate taxes. Very little, because very few people are worried about that anymore. And hopefully I can tell you enough to make you not worry, because a lot of my clients still ask me about estate taxes and what to be worried about as far as estate taxes. And the answer is usually, don't worry about it. Then we're going to talk about nursing expense planning, which is more and more the biggest concern of my clients. And then finally, we'll talk a little bit about VA pensions, which is a program that can help pay for nursing care or in-home care, other types of medical care, and it can boost up the bottom line of veterans, certain veterans, and we'll talk about who that is, and their surviving spouses, so a widow of a veteran. Now, they don't have to be a 20-year veteran, but we'll get into that later. So, afterlife planning, first part. So, afterlife planning, what do people want to do? What do they want to accomplish with afterlife planning? Well, they want to give their stuff to specific people. I want my radio to go to my son, and my car to go to my daughter, and $10,000 to go to the SPCA, the Society for Prevention of Cruelty to Animals, and you can do that. You also want to plan for dependent children. Now, a lot of people who come to me have dependent children. Many of us here have our children are all grown up and we don't need to plan for dependent children. But that is a major concern of many people. They want to preserve family land or family business. They want to leave something sometimes to be remembered by, a monument, a house, something like that. And sometimes they want to do some good in the world. They want to use their legacy to make a named scholarship, or to build a library, or to help people in other ways. Does anyone have an idea about the #1 charity that my clients like to give to? Just a guess.
Cancer.
Cancer, that's a good guess, but it's not the #1.
Church.
Church, that's another good guess, not the #1. The Dane County Humane Society is by far and away the #1 charity that my clients want to give to. They love their animals. They love their animals, and that's the way that they want to give to their animals, because of course animals cannot inherit from us, and generally they die before we do anyway. So, now, what happens if you don't plan? So if you look at your cheat sheet, and if you want to make a note, dying with no will or trust is called intestate. Intestate. That means no testament in Latin. So there's no last will and testament. The state law controls, basically. People without a plan actually do have a plan, but they didn't write it. They didn't create it. The state created it for them. In general, there's a lot of specific rules about who gets your stuff, but in general, your closest relatives are going to get it. And this, many people have the misconception that if they don't have a will, the state gets my money. That's not true. With one caveat. It is true if you don't have any relatives that are descendants of your grandparents when you die. So imagine your 2 sets of grandparents, and imagine all the descendants that they have. If you are the only person in that tree, then when you die and you have no plan, your assets will go to the state. They go to the General Education Fund. So, that's the only time when your assets go to the state, is if you don't have cousins close enough that they are descendants of your grandparents. There are unintended consequences if you don't plan. Some things are, you have probate proceedings in court. Nobody intends to have probate proceedings. There was one of my clients that said, no, I do want probate because I don't trust any of my relatives to do it right. So we need the judge to watch over what they're doing. So that was an intended consequence. Most people, that's an unintended consequence. Another unintended consequence of not planning is that you are legally able to get an inheritance and full control over an inheritance when you're 18 in Wisconsin, in most states, because you're a full adult. You can't be kept, that money cannot be kept from you. So if someone inherits when someone has not planned properly, and they're 17, they just have to wait till they're 18, and then they can use that money for whatever they want. And generally it's not what we probably want for them. In a second marriage situation, now this is the biggest pitfall that I see, and there's a lot of misconceptions about what happens if I have been married before and have kids, and now I'm married again. What happens if I die? Anybody have a guess?
Well, you said not the kids.
Okay, so one guess is the spouse gets it and not the kids. That's not true. It may be true in some states. In Wisconsin, the spouse gets half. The kids get half. And it gets complicated because usually the spouse's name and the decedent's name are on the house, though not always. So if there's 2 names on the house, whoever is surviving gets the house. So that's nothing to worry about. But the bank accounts, the personal property, the vehicles, all those things need to be split if you don't have a plan and you're on your second marriage. So if you've got kids that are not from your current marriage, please, please, please plan. I have seen so many fights and sadnesses happen because of a surviving spouse having to fight their stepkids for the money they need to survive on. and it's not good. Kids want their inheritance. Surviving spouse wants money to survive on. Sometimes one side or the other is too greedy, and both sides think the other is too greedy, and it's not a good situation. Planning can alleviate all that. Minor kids get a guardian that you would not want if you don't plan. Most of us here probably don't have minor kids. So here's that word, intestacy, dying with no plan. And there's James Dean. He died at the age of 24. No surprise he didn't have a will. Some background on him that we may not know, or you may not know, is that when he was 8, his mother passed away. So his father didn't really want to have a lot to do with him, unfortunately. He was raised by his mother's sister, his aunt. However, when he died, everything passed to his father because he didn't have a plan. They weren't even on speaking terms. So for his father's lifetime, he made $1 to $3 million a year for abandoning his child. That's unintended consequences. These are some questions that I like to ask my clients, and I just ask you to ask yourself, these things are the things that should trigger the question in your mind, do I need a plan? Do I want my finances publicized after I die? If you don't have a plan, or even if you have a will as your plan, it's an open record in the court. It's a probate process. Anybody can go in there and ask to see who got your money and how much it was. Do you know who your default heirs are? And we talked a little bit about that. There's rules of intestacy in Wisconsin. There's rules in every state. Illinois is different. If you have a house in Illinois and a house in Wisconsin, the house in Illinois is going to pass differently than the house is in Wisconsin. Each state has different rules. If you plan, though, it all goes according to your plan. Are all of your heirs financially responsible? That's a big one. Some people have families where they love their kids to death, but the kid's in and out of jail or has a drug problem, or they have that in-law, the spouse, that's controlling or just a nasty person. Everybody knows those people. Do you want to give full control over your assets to somebody who's not responsible or who's just going to give it to somebody that you hate? Have you been married more than once? We talked about that. Do you have kids that are not your spouses? Even if you weren't married before, as long as there's kids that aren't your spouses, if you die, then your estate's going to have to be split. Do you have stepchildren? Do you want to provide for them? Do you want to disinherit them? A farm or business always takes a little extra planning. If you're concerned with keeping the farm going, especially, or the business going, you need to have a plan that's going to allow your business or your farm to keep going instead of having a fire sale. Many businesses aren't worth anything after the owner dies because it's all in the owner's head and nobody else can run that business. So they've got a few staplers and a printer and that's it. Business might have been making $1 million last year, but this year it's worthless. So have a plan for that. Now, if you become disabled, can your health care and financial decisions be honored? Now, this is more about during life planning. Do you have disabled beneficiaries? If someone that you know and love and you want to give money to is on SSI or Medicaid because they're disabled, if you give them money in their inheritance, if they inherit money from you or from anybody, they can get kicked off of those government benefits. And they may be very angry with you because those government benefits generally provide better than a lump sum of money. So what they'll have to do is they'll spend down the lump that you gave them on the stuff that the government would have paid for, and then they'll have nothing, and that money basically went nowhere. And then they'll have to reapply for the benefits. An application for government benefits, if you've ever done it, I'm sure you all have, is not easy. It's a mess. So you don't want to get somebody kicked off of their benefits just by giving them an inheritance when you think it's a nice idea. You have jointly titled assets. Jointly titled assets are great for spouses. When one of them dies, it makes it easy to transfer to the other. Be careful though, some people like to plan for avoiding probate by titling their assets jointly in their kids' names. This is an area that's fraught with pitfalls. Be careful. I advise against doing that because bad things can happen, and we'll talk a little bit about that later. Do you have a will or trust that was done by someone who does divorces or other types of law, a general practitioner? This is areas that are very difficult to keep up on. As Peggy was saying, these things change year to year. It's hard to keep up with it. If you don't study in this area, you can make mistakes. And does your family sometimes disagree? This is more or less of a question that we know the answer to, right? Everybody's family sometimes disagrees. Somebody's going to say, Mom would never have wanted that. And somebody else is going to say, Mom told me every day that that's exactly what she wanted. If you haven't written it down, they will never agree on what you really wanted. And even if you did write it down, they'll sometimes disagree. So, better to write it down.
You don't have anything to say about it at that time.
That's right.
All right. So for planning afterlife, what are the tools that you need? And here's another spot on your worksheet. There's just 2 lines there. You can put commas in between them. There's more than 2 things. A will. A trust. Sometimes you can have a will and a trust. Sometimes you can have several trusts and no will. The trust can be revocable or irrevocable. They're good for different things. Different types of trusts can protect, say, assets from Medicaid spend down and recovery. Other kinds of trusts can't. They're probate avoidance techniques. More tools to plan with. Joint ownership. Be careful the pitfalls. But you can put real estate, bank accounts, and joint ownership. I want to just mention a few of the pitfalls of planning with joint ownership. It's wonderful sometimes for avoiding probate to put your kids on as joint owners. Imagine though that this is a case I saw last week. The mom puts the 3 kids after the husband dies, after the dad dies, mom puts the 3 kids on the house as beneficiaries or as joint owners, so that when she dies, the 3 kids just get it, and there's no need to go to court, and there's no probate in that. What she's just created is a very well-intentioned, but perhaps not so good thing. Because after she goes, now, at least one of the kids is going to want to sell. Very often, one of the kids is living there, and they're going to drag their feet and not want to sell. And the third one's going to try to make peace, and it's going to be a mess. They've also created a last-to-die situation. Joint ownership means when somebody dies, the other owners or owner gets full control of the asset. Now, I've known some guys that bought hunting land together and it's been a game for them. As soon as one dies, the other 4 now own it. The next one to die, 3 of them own it. What happens to the families of those who die first? They don't get anything. Same thing with what Mom just did. One of the kids, if they don't sell that house, if they can't agree to sell it, one of the kids is going to last longer than the others, and then their family is going to inherit it. Not the other 2. They're going to be out in the cold because they didn't exercise and eat right. So be careful about joint ownership. Another thing about joint ownership is that if your child is a joint owner on your house and something happens to their finances and they have to declare bankruptcy, what happens to your house? You're going to have to buy it again because the bankruptcy trustee is going to grab that, or somebody's going to sue your kid for that house because their name is on it. Now they're part owner, and your credit rating is going to be dependent now on your kid's credit rating. POD and TOD. Does anybody not know what that is?
Paid on death.
POD is pay on death, right, and and transfer on death. Very good. And that usually applies, POD is to accounts like bank accounts, and TOD applies to usually real estate or financial accounts, like not bank accounts but investment accounts. So it's pay on death and transfer on death. And that's one way to plan to avoid probate. But there's pitfalls in that too, and I'll talk about that in a minute. Another way to plan is to buy life insurance. Annuities. Those last after you're gone. Sometimes people plan with marital property agreements. When they get married, or even after they're married, if they put down who they want to get their stuff after they die, that can be a planning way too. You have to follow the marital property agreement as to who gets the stuff. You can also plan with buried treasure. Now, this was very famous from the old days of the pirates, but I've yet to have a client that's wanted me to help them with it, but I'm very willing. We can transfer your assets and put it all in gold and doubloons and jewelry, and we can find a chest, and I'll find you a place to bury it. So it's legitimate. There's no law against it, so I got a great place for burial. So there's some pitfalls to the PODs, and I want to talk about those. The biggest one that I come across, and PODs, do we have any bankers in here? Bankers are wonderful people, and I rely on them for a lot of things, but they are telling people more and more to put POD designation on their accounts. And they're very well intentioned. They want people not to have a problem, their families not to have a problem getting the money out of the bank after they die. Here's the problem. You have cash-starved estates. And I've seen this time and time again. Mom puts a POD on every account so that it pays on death automatically on her death. Mom has a house. After she dies, all the cash just leaves. It goes into the pockets of the kids. Now, we've got a tax bill that's due on the house. We have to pay the mortgage on the house. If there's a mortgage, we need to pay utilities. Where's the money going to go to pay that stuff if only thing is left in the estate is the house? You have to have a fire sale so that the house doesn't get foreclosed on. You're not going to get the value out of the house. The person that's in charge of the estate, the personal representative or the trustee, is going to be really ticked because they've got no money to administer the estate. They can't even pay for the funeral. Okay? So don't, please, put POD on all of your accounts. You're going to leave somebody with a big mess. Now, once again, if you got those 3 kids, you're going to have one of them that says, yeah, I just got this POD money. Here's money for the funeral, and here, use this to pay the taxes. That's my share. And one of them is going to say, you're not getting any of this money from me. I've already spent it. I just paid off my credit card and I bought a new car. Or my spouse isn't letting me give you any of this money. I'm sorry. We can't have it. And then you have people, unfortunately, siblings that won't talk to each other for years and years and years over this. So don't create that situation by doing what the bankers are suggesting that you do, is to put POD on all of your accounts. Think it through.
Dan,
Yes?
what should you consider putting a POD on?
When I do the planning for people, we don't put POD on anything. Because we've got everything figured out. So that one person's going to be in charge of all the cash, and they can pay the expenses, and they can pay for the funeral, and then whatever's left over, they divide like that. So some people insist on putting POD, and I say, okay, this account can be for your favorite grandchild because that's what you wanted, okay? Put POD on that account. As long as we've got enough other assets within, cash type assets within the estate that your administrator can administer the estate. So sometimes if you want to put one account or two accounts POD to a certain favorite niece or nephew or something like that, that's fine. Just so long as you planned for it, so that you know that there's a need for cash within your estate. Carol?
If you put POD on and name the administrator on a bank account, that would work?
You're talking the personal representative?
Yeah.
So, right, the question is, can you put POD to the personal representative? You can, but then it's their money. They can just put it in their pocket. They don't have to use it for the estate. It's legally theirs, and I've seen that happen before. And the personal representative has done just that. They put it in their pocket, and then they, you know, the funeral home has to wait till the house sells in order to get their money. Yes, ma'am?
If you both are still living and you have separate accounts and one dies, then how hard is it for the spouse to get the money to use if that other person's account is the one that has most of the money in it?
Okay, that's a good question. So if you're married and you have separate accounts, and you don't have a POD on either one, then you may, depending on the amount that's in the account, the magic number is $50,000. If there's more than $50,000 that's in one person's name when they die, then you have to have a probate type action. You have to go to court in order to transfer. If you're the surviving spouse, though, and it's less than $50,000, you can do what's called a transfer by affidavit. You swear out an affidavit and you sign it, and there's a form on the state website, for the court website, that you can just sign that form in front of a notary and you take it to the bank and they'll give you the money.
That's not a long drawn out thing then?
It's not a long drawn out process. It's just one form. They keep a copy of it, but you've got to list all the assets that are in the spouse's name, and then you're basically swearing that you're going to divide those assets according to whatever the estate plan is. So if it's your spouse and they've got other kids but they don't have a will, then you have to give half of it to their kids. So you have to follow the law with whatever money you get from there. So if they intend to give you all that money when they die, I suggest that they put you on as a joint owner on that account.
So it's only the house that automatically goes to the spouse, but none of the cash accounts?
They will if you got both names on them.
I mean,
But you said if you have separate accounts.
Mm-hmm.
Right,
So if there's other children, then they get part of it, and you get part of it.
right. So the solution, though, is planned. If you've got each got a will that says the other one gets everything, then there's no question. The kids don't get anything. Just do a plan. The solution is to plan, really. For all of these pitfalls, if you plan, you can avoid them. So with PODs, sometimes I see people do PODs and they say this account needs to go to this person, this account needs to go to that person, and then my IRA is going to have this other person as the beneficiary. And then they start living off their IRA. So then now this one gets more and they want to, oh, well, let's change that so that we can, it's just easier to use one document that controls them all and not use these PODs. Rejiggering, that by the way, that's a technical term. That was a third-year law school term. And the ability to have complex contingencies. Let's say, and sometimes happens, a family dies together in a car accident or a plane crash or something like that. And you've got the people that were on your POD accounts with you, and you all perish at the same time. Then what happens? There's no plan. You can have complex contingencies in a will or a trust. You can say, if this person dies, then that person. If that person dies, then that person. Like that. And in the end, if I have no living relatives, it all goes to Dane County Humane Society. Not the state. Well, you could say the state. They'd be not that appreciative, though. You probably wouldn't even get a thank you. All right.
Hey, Dan.
So, yes.
So if the POD, if the person dies and all the accounts say pay a death to someone else, how do they get that money? I mean, so my mom's account, it's just gonna vanish? Like, nobody can?
Whoever is on the POD form, they show up to the bank with a death certificate and their ID. And the bank just gives them money.
depends on your level of trust with the people you put on there.
The bank just gives them money, yeah.
What do they do, divide it by the number of people that are listed on the?
Right, if it's 5 people on the POD, then it each gets 1/5, unless it specifies. I mean, you could say half to this person, a third to this person, and whatever's left after a half and a third goes to the other, 6 people on there.
$20 bill.
Bankers know how to do that. All right, so we've talked about what's happening after life. Now we want to plan for lifetime. And these are just the next things coming up. So we're taking longer than I thought.
That's okay, you've got till 8 o'clock.
All right, so now we're talking about during life planning. What happened? What do you want to do? What do you want to make sure that you do during your life? Let's avoid guardianship. I've gone through guardianship proceedings. Has anybody here gone through a guardianship proceeding? Not on yourself, but on someone else? A guardianship proceeding is where someone is incompetent, they can't take care of themselves, and they haven't designated anyone else to take care of their finances or their health care. And now they have to go to court and find a guardian that's willing to watch over their finances and their health care and appoint that person in a legal proceeding. The terrible thing about that legal proceeding is the person has to be there and they have to listen to the doctor say they can't toilet themselves, they don't know what day it is, they don't know their own children, and all of this stuff. And in the semi-public proceeding in court. Nobody wants that. And then in the end, what they do is they sign an order that takes away their right to marry or divorce, to create a will or testament, to contract, meaning that you can't even buy anything anymore. Take away all your licenses to fish, hunt, drive. These are all things that happen in a guardianship that are completely avoidable if you do some simple planning. Plan for handling your income and assets. So that's what we want to do. Preserve the dignity of life and death. Let's avoid those court cases where the doctor has to come in and list off everything that we can or can't do or do that we don't want to really talk about. You can name your own agent, who is going to be in charge. You're still going to be, I will, some of us will, be just as incompetent, but you don't have to be declared incompetent.
So even if you have kids and you don't appoint anybody, you have to go to court for a guardianship?
Yes, if you're incompetent and the bank is not going to allow the kids to manage that person's finances because there's no power of attorney, they didn't plan. The nursing home or the doctor's office or the hospital is not going to allow the kid to tell the doctors what to do because they don't have a health care power of attorney. So this is a good time to point out one of the documents that was passed out to you, and that's the health care power of attorney.
What's the last document you got?
It's a very important document. It's a state form, and all the hospitals, if you've ever been in a hospital, they pretty much twist your arm until you filled it out. And what this does is it avoids guardianship regarding your health care. So that if on that form you tick off that you would allow somebody to admit you into a nursing home or a community-based residential facility, now you don't have to get a guardianship in order for that nursing home to accept you. I've been called up by the VA hospital on multiple occasions saying that Jim is being discharged, he's a veteran, he doesn't know where he is, he needs to go to the nursing home, but they won't take him because nobody can sign for him, and he can't sign for himself, so we needed to do a guardianship over Jim. If he would have just signed one of these while he was competent, no need. You just go into the nursing home and someone else signs. So you also get to choose who would be the one. So I encourage everybody, if you don't have one of these, it's a fairly simple form to fill it out. Have it witnessed by 2 people when you sign. And then give a copy to your doctor, and they'll scan it in, and it'll be in your electronic record file. So make sure that you talk with whoever you're putting on there and tell them that. And if you're the type of person that wants the plug pulled, discuss that with them also, because some people end up finding out that they're an appointed healthcare power of attorney and they have no idea what this person would have wanted. And that's a bad situation for you to put somebody in, where the doctor's saying, do we treat, do we not treat, and you don't know what they would have wanted. Nadine?
But that also needs to be reviewed, or otherwise your ex-spouse will be the power of attorney for healthcare, which you might not feel too good about.
Okay, Nadine makes a good point. Although I want to correct that, because the state law in Wisconsin says that anytime you appoint a spouse and then you get divorced, it's just like they died before you did on that document. So it's a nice thing in Wisconsin, but if you're in the middle of a divorce, of course, that's not going to help. But if the divorce is final, you don't have the ex-spouse problem. There is a problem with federal benefits, though, because the federal benefits don't follow Wisconsin law. So if you've got a federal insurance policy, like a veterans group life insurance policy or something like that, you do have to worry, but not on these documents. If you name your ex-spouse, it's just like they died and it won't be on there. They'll go to the next one. Yes.
Because of our ages, would we be better off naming one of our children as our guardian? Because we have these now, but, you know,
I always-
not getting any younger.
Right. Well, somebody's still competent, especially if they're your spouse, put them first, always.
Okay.
Now, on these state forms, there's only room for 2,
Okay.
one and an alternate. If you do them through our office, or if you go to another attorney's office, or you may be able to find another form online, I don't know. You can do as many alternates as you want. You could have unlimited alternates. On the state form, there's just room for 2, so just beware of that. Okay,
Of your office, if you chose.
yes, we'd be happy to help you with that. So, reasons to plan. We basically, here we go. Planning during lifetime, avoiding guardianship, basically, and preserve your assets is number 2. So avoiding guardianship, and that's for finances in the healthcare. So number 2 would be preserving your assets, and usually that's for nursing stay. Nobody can afford, once they're retired, to pay for nursing care unless they have well over $1 million in the bank. Some people do, most people don't. So if you don't plan for incapacitation, just like in a will or when you die, the state law controls. The guardian has to be appointed, and that's an expensive process. There's usually at least 2 attorneys involved, and your estate gets to pay for all of it. Court supervises your life, basically. And if you don't plan, all of your assets can be lost to nursing care. There's unintended consequences of not planning, and you may get a guardian that's not even part of your family. You may get a guardian that is a person that you didn't even like. Someone who is in your family.
Generally they are.
The people you love the most and you hate the most. They're all in your family. And you can get the expenses and embarrassment of court, and nobody wants that. So what are the tools for planning? We don't have a thing on the sheet about that. A power of attorney for finances, and I didn't give you a form for that. There is a state form for that, and it's okay. I never use it. You can find the state form on the internet. Look up Wisconsin Statutory Power of Attorney form. I talked to one of the guys that was on the state bar committee that created the form. He says, now Wisconsin finally has a form, but I'll never use it for any of my clients. And he created the form, and he's saying that. So There are limits to the form. The main problem with the form is it doesn't allow the power of attorney agent to gift. So there's no way they can do any Medicaid nursing home planning for you. It's impossible. So you can plan with powers of attorney, joint accounts, special annuities, trust. This is the other big one, the healthcare power of attorney. A living will. A living will is basically a pull-the-plug document. It's a 2-pager that says I don't want to be kept alive by heroic means or unnecessary means and allowed to die naturally. There's also cyanide.
Yeah.
Let's
Slow
get rid of cyanide. I'm sure you can imagine. Go ahead.
Is there something called the durable power of attorney as well that would encompass all of these?
The durable power of attorney is generally referred, durable means that it's not going to go away if you become incapacitated. The old rule used to be that if you create a power of attorney and then you become incapacitated, that power of attorney is no longer any good. So the durability can apply to a healthcare or a financial power of attorney. However, it's almost always used to refer to a financial power of attorney. So it's not an over-encompassing document. I've seen documents in other states, from other states, that people bring into my office that do the financial and the healthcare all in one document. In Wisconsin, that's not the practice. We don't do that because anything that confuses the doctors is bad. They will balk at that. If they see a line or something that they're not familiar with, they don't like to touch that. So we just use what people are used to. So we keep them separate. The financial and the healthcare powers of attorney should have one of each.
Dan,
Yes?
am I right in thinking that you have a DNR under certain situations and you code during surgery and you know, you're 102 and you want to go to the great beyond, don't surgeons require you to suspend that while you're in their care so that they do try to revive you, even though you don't want them to?
I don't know.
She's correct.
She is correct.
Okay, so
I just had surgery last week, so I know that that's.
I'm being told that if you do have a DNR order or you've told people that you do not want to be resuscitated, that doesn't count during surgery. Okay? Did I get that right? Okay.
My understanding, you would only get a DNR from a doctor, and only if you have a life-threatening illness. You can't just say to people, I don't want to be resuscitated. I had a gal that came to my Reedsburg session who was probably 35, and she wants a DNR because she never wants a medical doctor to touch her body. Excuse me. But if you're in a car accident, they're going to try and revive you. So the DNR is kind of a narrow area, and I would talk to my doctor about it. But Nadine, you have some more information?
Well, I just went through this with a friend who has had a serious heart attack, and the surgeon or the doc was really clear that even just having a cardiac cath where stents are in place, that if he would arrest, they would do a full code because he was essentially in the midst of a surgical procedure.
Okay. So that's interesting. I didn't know that. All right, so we did plan for afterlife, plan for lifetime. Now let's talk about estate tax. This is going to be really quick. Estate tax. If you have less than $5.45 million to pass on to your heirs, you have no worries about estate tax in Wisconsin. Okay? If you have more than that, we're not going to waste time talking about that here. You need to hire yourself a good attorney. I know where there's one you can find to help you plan, okay? So, there's no estate tax if you have under $5.45 million to pass. Now that includes life insurance, IRAs, real estate, and any other assets. So a lot of people don't realize that life insurance is included. But all that goes into the estate tax. Most people, 99.6% of us, don't have to worry about that. And if it's a couple, you can have 10.9 million. You double that.
If you have that, let me know, I want to be adopted.
Now, do they both have to die at the same time? Because if one dies before the other, that the surviving member of the family has $10 million. Then he has to pay taxes, or she has to pay taxes.
That's a good point, sir. They've changed the law in 2012 so that now we have portability for spouses of the estate tax exclusion. There, you have to follow the rules though, meaning that you can take your former spouse's or your dead spouse's estate tax exclusion with you and add it to yours, so that you can still have the $10.9 million if your spouse died before you. But one of the very important ways that you have to, one thing you have to do in order to get that portability is you have to file the estate tax return of the first spouse that dies within 9 months of their death. So as long as you do that, and there's no tax when the first spouse dies because you have unlimited transfer to a spouse. You can give billions of dollars to your spouse and there's no estate tax. So as long as you just do the estate tax return, say zero due, when the second spouse dies, they claim that portability and then they get the 10.9 million. People ask me, well, there are some people like this. We've got $25 million and we want to avoid the estate tax. What can we do? And I say, make sure you never travel together. And as soon as one of you dies, the other one needs to get remarried right away. And then just keep doing that. You'll never have to pay an estate tax, but of course, your kids are going to be long lost from that long line of spouses. It's one of the reasons why the royal families always marry their cousins. To keep the money in the family. All right, so let's talk about nursing home expense planning. Nursing home expenses claim so many lifetime earnings. So many people have their lifetime earnings that they had planned to pass on to their kids or use for their security during old age disappear during their lifetime because unfortunately they needed nursing care. I want to talk to you about two different types of, so the magic number on estate tax is $5.45 million on your sheets. Next time is two types of estate planning, or two types of planning for nursing care is the pre-planning and the crisis planning. The pre-planning is when you figure you've probably got 5 years before anybody needs a nursing home. The crisis planning is when somebody's already in the home or they're about to go in the home. Of course, there's a gray area when you think you might have 1 to 2 years, and that's hard to plan for. I want to talk about disease discrimination. There's discrimination in this country and it's legal. I want to tell you about it. It's called disease discrimination and there's no reason for it. There's no good reason for it except that that's the way they wrote the laws. There's two government insurance programs that we pay our taxes for. One is called Medicare, the other one's called Medicaid. These are both health insurance programs, both taxpayer funded. Medicare, everybody gets, except the illegal aliens, everybody gets when they turn 65. Medicaid is different. If you have cancer, your treatment is in the hospital and outpatient. This cancer treatment is paid for by Medicare. You don't have to dig into your pocket and go broke before Medicare starts paying for your cancer treatment. Because of the way they wrote the laws, there's discrimination though. if your disease is not cancer, but it's Alzheimer's disease or some other form of dementia, or just general old age that keeps you from being able to do the daily tasks of living. Because then your treatment is in a nursing home. And the way they wrote the rules, Medicaid pays for nursing care. And Medicaid rules, not everybody gets that. Only the poorest people. So, cancer, you get to give your kids all of your life savings. Alzheimer's disease, your kids get nothing. Is that fair? Is that a good way to run our healthcare system in this country? I don't think so. I have no problem helping my clients plan to qualify for Medicaid and save their assets because I don't like discrimination. Some people have a moral problem with it. They say it's cheating. You should go broke because that's the rules. That's not the rules. We follow the rules in our law office and other people that do this. We follow the rules. They keep changing the rules so it's harder and harder, but we follow the rules. Some people who plan have money for their kids, and some people that don't plan don't have money for their kids. And it's a shame that it's so hard to do. It's good for me, because I get to charge people to help them. So here's the government's plan. So if you don't have a plan, the government has a plan. So, number one, the government's plan involves spend down, and that's on the bottom of the first sheet, or first side of this. Spend down. That means getting rid of all your assets that Medicaid is going to count against you. The second part is estate recovery, and that happens after you die. That's when the county comes back after whatever's left and grabs that to pay the Medicaid bill that they've been racking up and keeping track of during your lifetime. So that's the double whammy. Now the spend down, some people would say, that's not so bad. You know, you pay for nursing care, but you get to keep your home. Even though you're living in the nursing facility, you get to keep your home as long as you say, I plan to return there someday. Even though it might not be really possible. As long as you say you intend to return there, they'll let you keep your home. Don't rent it out though, because then it becomes a business and now you got to sell it in order to pay nursing care. My home is my biggest asset. Why am I worried now? The kids get the home. No, they don't because of estate recovery. So they come back on the back end and get it. So those are the two things. Now your plan, not the government's plan, should be keeping your house for the kids after you go. Keep your farm for your kids. Keep some money for your kids. But keep your money for your security. One thing, here's another argument that I use for the people that say you're breaking the rules and you should have to spend down everything. Why should you be without security during your lifetime? The government plan only lets you save $2,000 in the bank, at the most. What if you now want to move to California to be by your kids and move to a nursing facility over there? How are you going to do that with $2,000? You can't haul all that by yourself. You're going to have to hire somebody to move you. There's a lot of expenses that go along with that. What if you want to go on vacation? You got $2,000, you can maybe go on vacation this year, but not next year. How are you going to get your hair cut every week? They give you $45 a month, and that's it. $45 a month. You can't even buy toothpaste and a good haircut in a month for that.
I'll bet you can. I couldn't resist, Dan, I'm sorry.
Yes, I can. Toothpaste costs me more than a haircut, but that's unusual. So I got a couple of scenarios, and this is just very 50,000-foot overview. This is the dad planning scenario, and that's the pre-planning. So he's got at least 5 years, we think. He's in his 60s. Mom passed away from cancer, so he's got his assets left because Medicare paid. He's got $300,000 nest egg plus a house. So what would we suggest that he do with this if we think that he's got plenty of time? We tell him to put about $225,000 in his house into a Medicaid Asset Protection Trust. That's an MAPT. One thing about the MAPT is you gain control from the government, but you have to give up some control to someone that you love. Who's in control of this? Whoever you choose that's not you or your spouse. That means a child almost always. The child, someone that you trust in order to use this asset for your benefit, because you no longer, you're giving up full control of the levers on that. But you're gaining the control over the government telling you what you have to do with those assets. You put the other $75,000 over here in the revocable living trust. You use that for your home repairs, vacation, whatever you want to use it for. If this runs low, the kids just take some money out of here and you gift it to you. Make a gift out of it. And you get some more back out of here, out of your Medicaid Asset Protection Trust. And then after 5 years, let's say, Dad has to go into a nursing home. Well, this is locked in. Now the 5 years is a big deal. So the Medicaid rules are you can't give anything away or transfer it to an irrevocable trust within 5 years of applying for Medicaid without getting a penalty period. So the penalty period is a time from the time you qualify for Medicaid otherwise and the time they'll start paying. If you give away $7,000, you have to wait a month before you can qualify for Medicaid. If you give away $14,000, it's 2 months. That's how they calculate it. So if you put your house and $225,000 in, and the next day you try to get Medicaid, you're going to be disqualified for many, many months. However, after 5 years, you don't even have to tell them that you gave away that. So, 5 years pass, Dad's in the nursing home. The $75,000 that he kept out goes to pay nursing expenses. The rest of it stays in a pot that the kids are in control of. They buy him back rubs daily because he really likes that. They have somebody come in and read to him. He gets his hair cut whenever he wants. They do his toenails for him. He gets the big screen TV they buy him and any computer equipment, whatever they want out of all this money. Well, the Medicaid program, the government insurance that he's paid his taxes for throughout his life, pays for the nursing stay. They can even take this money and pay for the difference between the semi-private room, which is what Medicaid will pay for. Semi-private, by the way, means not at all private. You get a roommate and a curtain, basically. You can pay the difference, 25 bucks a day, between the semi-private and the private room. So now you get your own room. So during the lifetime, this is for Dad's use, as long as the kids properly manage it. And then after he's gone, whatever's left goes to the children's inheritance, if there's anything left. Planning in this way has saved $225,000 plus the house. Whereas Dad would have otherwise, if he's in the nursing home long enough, spent down to $2,000, and then after he's dead, they'd have taken that and the house. That's the difference between planning with your plan and planning with the government's plan. So here's the failure to plan. What happens? $300,000 of Dad's money goes to the nursing home expenses while he's alive. The house gets taken after he's gone, and there's nothing left for the kids. There's no security for Dad after he's spent down either. He doesn't have that money to get the haircuts and the back rubs and the vacations at Disney World. All right, so this is mom's scenario. $300,000 nest egg plus $100,000 home, so just like Dad's case. Only she needs to go into nursing care right away. By the way, both of these cases are for single individuals. Planning for a couple is more complicated, but you get the idea. $300,000 nest egg plus $100,000 home. What we do then is we do some calculations according to what the Medicaid rules are. We pull out the Medicaid rule book and we say this much, and this is going to be the penalty period, and we split up the assets. These are the assets that you get to keep, and you split off these assets that you're going to have to pay to the nursing home. And you put those in a special kind of a Medicaid compliant annuity. So now we had to sell the house in order to do this plan. Or we could just put the home and $130,000 into this Medicaid Asset Protection Trust. Either way, we're going to get a long penalty period when we give this away, because we're going to give this away one day, the next day we put in the Medicaid application. We've calculated what the penalty period is going to be, and how do we pay for care during that penalty period? The annuity pays it. That's the planning method. So the annuity pays through the penalty period. We've calculated so that the month the annuity is over with, Medicaid kicks in. Now, you've gone through the $170,000. It's a lot of money. However, there's still $230,000 here for your security while you're in the nursing home that your kid is in charge of. And then if there's anything left, your kid gets it. This is just a 50,000-foot overview of some of the most common methods for preserving your assets by planning. Most people who go into nursing facilities believe that there's nothing they can do. Sometimes their children are so harried and they had to come in from Philadelphia to try to clean out mom's house and get her into the facility. They don't think, maybe I should talk to a planner that does Medicaid planning. So many people I talk to say, if I'd only talked to you 3 years ago, we'd still have $150,000 that we could be using for mom's care. But now, right now, we're doing the Medicaid application because she's down to $2,000 and nothing else. So, if nothing else that you take away from here, just take away the idea that if you know somebody that's going into a nursing home, tell them to talk to a Medicaid planner, an estate planner that does Medicaid planning. Now there's not that many of us out there because they keep changing the rules and they keep making it harder and harder, and it's very complicated. But it doesn't usually cost anything. It doesn't cost anything to talk with me. And if you can do something, I'd be glad to help you do it. And I charge for my services, but when you compare $230,000 to what we charge for this, most people find that it's worth it. So now let's talk quickly about veterans pension because I got 2 minutes to go. So, veterans pension rules are, you have to be a veteran. You have to serve 90 days continuous active duty. That precludes somebody that went into the reserves or the National Guard and never got activated. You can't collect this if you were only a reservist or a National Guards person. I say only, that's great service and it's very well needed, but it doesn't qualify for this pension. One of those days of active duty, and only one, has to be during one of these wartime periods. It doesn't mean you had to be overseas. It doesn't mean you had to be shot at. You just had to be on active duty somewhere during one of these wartime periods. Like I say, you don't have to be in combat. There's no requirement. You want to get the dates?
Yeah.
Please.
All right, World War II. We don't do World War I because I don't think anybody's still living yet. World War II is 12/7 of 1941 to 7/25 of 1947. Any service during that time. Korea, 6/27 of 1950 to January 31st of 55. Vietnam, August 5th of 64 to May 7th of 1975. And then the Gulf conflict has different rules. It's August, I think it's 5th, I don't remember. August of 1990 to the present. They haven't closed the door on that one yet. There's slightly different rules for Gulf veterans. It's harder for Gulf veterans to qualify for this slightly. They don't have to be in combat. They have to have an honorable or general discharge, meaning no negative discharge, bad conduct discharge, other than honorable. That doesn't work. And here's the one on your sheet, on the back page of the sheet, the monthly income requirements. The first blank is income, and then the word, and then on the sheet it says minus medical expenses in the next blank. Income minus medical expenses is less than $2,100 and $2,120. Now that's the case for a lot of people in assisted living, almost everybody. That's the case for a lot of people who have at-home care. But it's income minus medical expenses. So especially if somebody's only income is a fairly small Social Security check, it's not hard to meet this requirement. Now, I put $2,120 on the sheet, but there's different levels for different types of qualifiers. So an unmarried vet is $1,788. The married one is the highest level, is $2,120. The surviving spouse, single surviving spouse, is $1,149. That's the lowest level.
Does that include your VA disability as income?
It includes, I don't know. I know it includes all taxable income, and it even includes gifts. If you get a gift regularly from somebody, they include that as income.
VA disability isn't taxable.
It's not taxable, I know. So I'm not sure whether that's included, and that's something I would have to check on. But in general, all income. They're basically wanting to help people that don't have enough money to pay for their medical expenses. And also another question that I need to answer for myself on this, do people with a 20-year retirement benefit from the service, are they eligible for this? And I'm not sure about that either. So, and then your assets have to be in limits. Now this is something that we can help you with these trusts that we do. So people that have more than $30,000 to $50,000, as it's not a bright line, but we shoot for 30 or 50 and they don't give us problems with these applications. If you get over that, they start to get nervous. And then here's just a chart of the benefits. So the maximum benefits that you can get. So if you have a zero income or less, meaning that you're spending more on medical expenses than you actually bring in, then you can get the max benefit. And these are the maximum. So there's 3 levels of care, benefit levels, and this is the last ones on your sheet, are the basic. The basic is just anybody whose medical expenses subtracted from their income is below the limit. The homebound has special rules. The middle level of care is you have to be basically homebound. A person that can't drive, that maybe only gets out once a week for church, they can be considered homebound. And then the highest level of care, and some of you may have heard this phrase before, is aid and attendance. And that's the highest level of care, and that means you need help with certain activities of daily living, like toileting, getting out of bed, feeding yourself. If you meet those certain medical criteria, you can get the highest level. So there's 3 levels of care. There's 3 different categories: the veteran and the spouse, the veteran only, and the widow or widower. And that's it.